So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital
Employers have to
revolution.
comply with the Title VII of the Civil Rights Act of 1964, and we've got to talk about this today. It impacts you, it impacts me, and this goes to triple canopy. So, if you're not aware, if you're not involved in these areas, triple canopy is a private security company. They're most familiar and frankly most famous for merging with the security firm Academy, which was basically Blackwater, which if you weren't around in the mid 2000s, mid aughts, you might not be familiar with Blackwater, but they did some truly heinous things in Iraq, I believe in Afghanistan too. Ultimately, they became the Constellus Group, and it's a fairly big company. And then Triple Canopy is sort of an over I don't know, an umbrella group, right? So they provide elite security forces across the world, effectively. I mean, they do it for military bases and energy sites, and of course, embassies and airports and things of that nature. And the case that we're going to be talking about today is one coming from the Equal Employment Opportunity Commission and what actually went down. So Triple Canopy, of course, had to pay $110,000 to settle this case, and we're going to go over what it was. This employee who filed a charge said that Triple Canopy denied the religious accommodation because he held a Christian belief that men must wear beards, but didn't actually ever substantiate it, bring in a documentation from a religious leader, literally anything. And he didn't bring in anything to the table. And he didn't really do anything to support it. Conversely, Triple Canopy didn't really engage with him, and then ultimately, subjected him to intolerable work conditions where he effectively quit. It's called a constructive discharge. Constructive discharge, or also known as constructive dismissal, occurs when an employee resigns from their job due to intolerable working conditions created by the employer. In a constructive discharge situation, the employee's decision to resign is essentially forced by the employer's actions or the work environment, even though the employee technically initiated the resignation. Key elements of constructive discharge include intolerable conditions, employer's actions, objective standard, employee's reaction, and it's significant in employment law because it may allow the resigned employee to make legal claims similar to those available to employees who were terminated, which might include complaints of wrongful termination, discrimination, or other legal actions. When I started digging into this case, I realized that Triple Canopy has had a lot of issues with beards. Quite a bit. There's one with Luis Martinez, and he asked to have a beard and received repeated questioning about the beard and urinalysis tests under false pretenses. There was a few others that had the same problem, and really, frankly, part of what's happening here is the government's requirements for presentation and Triple Canopy attempting to sort of comply with those. Many government organizations specifically surrounding their security have specific gender related requirements about how someone is to present at a specific guard duty. And Triple Canopy is almost entirely made up of former military folks who are, frankly, used to A, following orders, B, not having beards. And so it's one of those situations where this issue comes up quite a bit because Triple Canopy is in a bit of a rock and a hard place, right? Their government, their customer is saying for this arbitrary reason, you can't have a beard, and then the Triple Canopy then has to navigate that situation, right? And they seem to be doing a really poor job of it because the biggest thing, the most important thing would be to, at least attempt to navigate this, which it seems like they didn't do here. They didn't really make any concerted effort, and then ultimately then discriminated against him once they got in the job and put something on him, right? Not scheduling him for work after he complained to the EEOC. And that's, I think, where this triggered the EEOC for filing a lawsuit against Triple Canopy. They knew that, going after him after filing an EEOC complaint was really, I think, the last straw. I'm not sure that they would have taken this on otherwise. Um, I think that that's what you're seeing here. I think that they really did a poor job. But on the flip side, this is a really tough ask, right? There is no formal religious denomination that I'm aware of that requires a beard. He didn't belong to one, if there were, right? So even if there was a religious denomination in which he could belong to, he didn't belong to one, and then held a Christian belief that men must wear beards in direct contradiction to the customer who has this sort of arbitrary requirement on the employer. So clearly, employers must navigate the religious discrimination and retaliation very carefully. But I wanted to shed a little bit of light on this particular topic because I found it to be quite interesting, and I thought that this sort of grander evaluation of accommodating all that come your way could lead to some probably unwanted behaviors. And I'm curious where my listeners, my watchers fall on this. Do you think that even if you can't sort of articulate a belief and there's none that you're aware of that's been established, that you should still accommodate? Does that make sense? Is it, where does that end? Where does that stop? And is that truly still a reasonable accommodation, even when your customer doesn't want it, which I believe is the case here. Let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you in the next video. Bye, guys.